Good afternoon and welcome to the ALCTS webinar, The Black, White, and Gray Areas of Licensing, a review and update for librarians and publishers. I'm Kristen Martin and a member of the ALCTS Continuing Education Committee. Our presenters today are Becky Albitz, Bob Boissy, and Tracy Thompson-Przylucki. Becky is the Electronic Resources Librarian at Penn State University. She holds degrees from the University of Rochester, Penn State, and the University of Pittsburgh, and is currently working on her doctorate in higher education at Penn State. Becky has co-taught the ARL online licensing workshop and also has given numerous presentations and workshops on copyright and licensing issues. Her book, Licensing and Managing Electronic Resources, was published by Chandos Publishing in 2008. Bob is the manager of Account Development and Strategic Alliances for the publishing house Springer, where he's worked for the past 9 years. Bob received his MLS from SUNY Albany and a Certificate of Advanced Studies from Syracuse University. He currently serves as the Vice President, President-elect of the North American Serials Group and contributes to 2 NISO working groups, Shared Electronic Resource Understanding, CIRU, and Presentation and Identification of E-Journals, PIJ. Tracy has served as the Executive Director of NELCO since 2001. In that capacity, she negotiates license agreements on behalf of more than 115 law libraries throughout the United States, Canada, and the United Kingdom and Australia. Prior to joining NELCO, Tracy served as International Reference Librarian for Lillian Goldman Law Library at Yale Law School. She holds a BA from the University of South Florida and a JD from Yale Law School. Compared with some other ALCTS webinars, the format of this webinar is going to be a little different. We're going to have more time for questions and answers. Our presenters will provide some information based on your questions that you submitted in advance, and we've also left a lot of time for additional questions from participants. If you have a question for Becky, Bob, and Tracy, please type them into the question box on your screen, and we'll have several question breaks throughout the presentation. Also, please note that the session will be recorded, and you'll receive an email shortly after the conclusion of the webinar with a link to the recording. You'll also receive a copy of the slides. Finally, if you're interested, the ALCTS committee invites you to use the Twitter back channel, which is #ALCTS, up on the slide, and you can interact with other participants during the webinar and continue the conversation following the webinar. However, note you should submit questions for the presenters into the question box on the screen. Neither the presenters nor myself will really be monitoring Twitter during the presentation. So now I'm going to turn the presentation over to Becky, Bob, and Tracy, and there may be a slight delay.
Okay, can everybody see my slides? Bob, Becky, can you see them?
Yes.
Okay, great. So I hope we have time for questions and answers. The format of this presentation is a little different. We did a survey in advance of this program with questions that Bob, Becky, and I had put together to find out what it is that you all wanted to learn in this session. We took those questions and we're going to respond to the majority of them, and hopefully we'll have time at the end for more Q&A. But as Kristen said, if you have questions, please type them into the chat box. One of the questions that sort of frames up the whole discussion was presented by one of you in the survey, and that question is here: what are the most important things to know before a librarian begins a license negotiation? And that's kind of a great question to start with. So we put together these 4 general considerations before anyone starts in a license negotiation process. The first is that everything is a target for negotiation. I would be tempted to say everything's negotiable, but that's not always the case. But I would say it's a target for negotiation. Becky, do you want to look at number 2?
Sure, sorry about that. I keep messing up my mute and unmute. Sorry about that. It's very important when you're when you're beginning a negotiation to understand exactly what type of institution you're negotiating for and what the needs of your libraries are. So for example, if you're a state institution that requires you to have walk-in access, you know that that's something that you have to look at right up front before you start negotiating any of the other issues. If you're a multi-site institution, you have to be sure to extend that access to other locations. You basically just need to understand exactly what your institution is, what your needs are, and once you have those in place, reading a license becomes much easier.
I sometimes even encourage people to create their own standard license agreement for their institution, just as a starting point for any negotiations with vendors. Number 3 is be prepared to walk away, if possible. Sometimes you'll know that you can't walk away from a negotiation, that you absolutely have to have this resource. But you should know going in, what are your deal breakers? What is it that would make you walk away? What do you absolutely have to have, and what can you live without? And then finally, just keep in mind in any negotiation that it's not personal. It is definitely a business relationship, and you want to maintain good relationships, because even if the negotiation that you're working on isn't successful now, you may be coming back to that that information provider or publisher in the future, and you want to make sure you have good, strong relationships and you haven't burned any bridges by making these negotiations personal.
And if I could add, it also helps sometimes in negotiating the business agreement side of it. So if there are options for reducing the price, maybe adding additional content, you always want to keep that door open and maintain a pleasant working relationship.
And we want to go ahead. We've got a series of polls during the course of this presentation just to give us a sense of who you are. So we want to go ahead and ask the first question. What's your current level of involvement in licensing? If you could just take a moment, we'll give you a few seconds to answer.
Mix.
All right, it looks like we've got some answers here. I'm going to go ahead and close the poll. We've got 86% of you have voted. I'll give you another couple of seconds. %. All right, I'm going to close the poll, and you should be able to see here. Are you seeing the poll results?
Yes.
Okay, so you can see that we've got 35% of those who are on this webinar are fairly new to the process with no experience. 32% have done a few license agreements, 31% are old salts, and 3% are not actively involved but supervising others who do licensing. So that gives us a good sense of who's on the call. So those of you who did complete the survey that we had asked for, we appreciate that, and as you'll see in the course of the next several slides, we're going to address some of the issues you've raised. The first question that we posed was, please provide up to 3 licensing terms you'd like to have identified during the webinar. And we're just going to walk through some of these terms now.
Yeah, I think this is my turn to jump in. This is Bob. And I volunteered to talk about at least a couple of terms to begin with because they are fairly straightforward. First one is fair use. Fair use is defined in Section 107 of the U.S. Copyright Act on fair use. So if you want to find out more about it, it's not a long text to read. It takes about half a page and covers what is fair use. Now, there's a lot of interpretation wrapped around this, but the basic statement is in Section 107 of the U.S. Copyright Act, and it covers nonprofit, you might say non-commercial, educational use, and that involves use for criticism, comment, teaching, scholarship, and research. If in the case there are some types of needs to adjudicate between what is fair and what is not in a given situation. The things that are considered are the total amount of the content that was used, and for example also the effect of the use on the commercial market for that content. So those are some of the things that go into fair use, and I invite anyone interested to investigate. Again, it's easily found on the internet, Section 107 of the U.S. Copyright Act. The second piece that's easily found relates to that, and that's Section 108 of the U.S. Copyright, covering interlibrary loan. We had the question about secure interlibrary loan. I think you have to start with the basics, which is Section 108 of the U.S. Copyright Act. And there you find out, as you go from there and into the CONTU guidelines, which are a kind of a spin-off of that. The CONTU guidelines dictate that content should be used, we call it the rule of 5. That is 5 uses from, for example, the same journal in the same year within the first 5 years of publication of that journal. So ILL folks who are old hands will know about that, but the new and wrinkles and twists on ILL have to do with whether or not a license allows the use of the most modern techniques to send, for example, articles and book chapters electronically through ILL systems. And that is something that you want to be careful and take a look at. The publishers would like that to be a secure process and somewhat under control, but take a close look at that in your licenses. There is another piece that I'll put in here, just archival rights and perpetual access, I think deserve a mention because you asked about it. Archival rights, generally speaking, they're close but not the same thing. Archival rights really relate to the right to have a backup or an archival use copy of the materials that you may have purchased. The right to make a backup or use a backup in the case that it's needed. That, for example, online access is no longer available to you. So archival rights are the right to make an archive, and you look for the ability to make a backup or a copy of the materials you may have purchased. Perpetual access is something different. I used to laugh about this and say it's more of a religious term than a legal term, perpetual. But I think that the idea basically is that you're talking then about the online access and the continuity, the ongoing continuity of that access, and wanting to make sure that a publisher, for example, is willing to offer that in the long term, and also that embraces concerns about content switching from one publisher to another, in which case you want to investigate whether the publisher is part of the transfer code of conduct, which would assure more regular a kind of assurances of continuity of that access if content moves from one publisher to another, for example, with journal society publishing. And I think I'll turn it over to one of my colleagues to look at some of the other terms.
Okay, hi everyone, this is Becky. I'm going to talk about a couple of other terms. Someone had asked for a definition of what scholarly sharing is. And scholarly sharing really is the transmission of a document, usually a book chapter or an article, directly from one person to another without the intervention of an interlibrary loan department. This is becoming more common in licenses. They're permitting us to share them between or amongst a group of researchers who are working on the same project, even if the colleague is not at an institution that subscribes to the same resource. The other term that I was asked to look at, these are actually two terms and we put them together, are electronic course packs and electronic reserves. It's kind of interesting, Tracy and Bob and I, when we were prepping for this, we had very different definitions of what we thought an electronic course pack was, which I thought was kind of interesting. So I'm going to go to electronic reserves first. Electronic reserves, in my mind, is a service provided by a library, usually confined within a module of our integrated library system, system. So we're a CERC shop at Penn State. We have a reserves module. That module protects the content, forcing students to authenticate. They also have to select the course or the professor, so the resources are essentially limited to students within that course. It's also fed into our course management system, which means students have to be enrolled in the course in order to get to the link, in order to get to the electronic reserves, which have been, again, prepped by the library. And in that situation, the library takes care of any rights or payments. At least in Penn State's case, we take care of any royalties that we believe need to be paid. Electronic course pack, I think, is defined a little bit more loosely. We think that's probably more generated by the professor, housed within the content links, or PDFs are confined usually within a content management system of some kind, and thus only allowed or only accessible to students in the course. I think the important thing about these two definitions is to make sure if you have a question about what they mean and what you need to be able to do with the content, that the license itself defines these in a way that you understand and you agree with. So if the license says that you can use something for electronic reserves but not for an electronic course pack, you need to work with that company to find out exactly what those parameters are and make sure that's defined within your license. Now I'm going to turn it over to Tracy, who's going to talk about a whole bunch of legal stuff.
Well, that's really interesting point that you made, Becky, because I think that's true with any of these definitions, and that is, if you don't understand the definition, make sure that you ask, that you work with that publisher, that information provider, and you agree on what that definition is. And you can start your license agreement with definitions. You can include the definitions in the first section of your license agreement so that everyone's clear on the terms. So that's a really good point. I'm going to talk a little bit about some of these terms like derivative works. And the idea of derivative works are works that are based on another work in its entirety. So for example, something like a translation, or maybe if it's a book and it's a movie version of that book, those are derivative works. But they require the permission of the original copyright holder to make derivative works from that particular original copyrighted work. And the derivative work itself is typically then also copyrightable as a unique work. So that's what's meant in a license agreement by derivative works, as opposed to just simply citing a work or using a work as a reference. It's really about a completely new work that is also in its own right copyrightable. Indemnification was a question that a lot of people raised, a term that a lot of people wanted definition on. Now, the idea behind indemnification is just the parties are trying to allocate risk for harm to third parties. So in the contract, there's the licensor and the licensee. And when indemnities come into play, or when someone is trying to allocate risk for any harm that could come to a third party, so someone outside of that contract agreement. What you will typically see is a unilateral indemnification where the information provider or the publisher is asking the library to indemnify them against claims from third parties. You really want to avoid those kinds of indemnity clauses, and typically, I mean, I don't think I've ever had a case where we couldn't negotiate that, and you either want to remove that unilateral indemnity or you want to have sort of dueling indemnities so that they are also indemnifying you against any third-party damages that may occur as a result of use of that resource. But for the most part, I think you really just want to ask that any indemnification clauses be removed, and most vendors and publishers are more than willing to do that. Warranties, there's all kinds of warranties that you want to think about. Warranties of fitness for purpose, whether the product that you're licensing is fit for the purpose that you are expected to use it for. Oftentimes the publishers or information providers don't want to provide any warranties, even of fitness for purpose. So what you might see, the warranties that you do want to be sure are included in a license agreement are that the information provider or publisher is authorized, they warrant that they are authorized to license the content to you, because oftentimes they might be aggregators, and you want to make sure that they are giving you a warranty that they have the right to license that material to you. The next one is material breach. Material breach typically is it's a phrase that's subject to interpretation, but it typically means that the breach is something that affects the license or the contract in an important or vital way. And so those terms are all subject to interpretation. What you might want to do is you might want to define what a material breach is, and you can do that in the terms of the license. So you could say something like, you could say something about the percentage of content within a given resource. If that amount of content is removed from the resource, that could be seen as a material breach. So there will be some breaches that that affect your use, but they don't rise to the level of a material breach. So it's just something, again, you want to be clear about. You want to define it in your license agreement if you have certain kinds of things that you want to be seen as material breaches. CRU, we heard a little bit about the shared electronic resource understanding, and that is an alternative to license agreements, and it's really something that is not yet making a lot of headway, but I think people are looking at it more and more. It is a NISO project, and Bob, did you want to say anything about it? You're serving.
Sure. Yeah, no, it's a recommended practice, and there is an update to it, which is just finishing its period of comment for the final stage. And I think it may be ready in this updated version. The updated version of CERU is designed to embrace all kinds of electronic resources, both clearly in its language, both electronic journals and electronic books and databases and other types of electronic resources. So that updated recommended practice for 2012, you should look for that on the NISO web pages, and I think folks will find that it is not intended to be a license. It is intended to be a shared understanding of the common practices used between publishers and clients and libraries. The idea is that what you do is you state what you think should be the case in common uses, authorized users and uses. And then if there was to be any kind of a dispute, heaven forbid, really copyright law would be where any dispute would be settled. So it kind of puts any legal activity back into copyright law where it was really before Internet licensing came about. I did want to add one other comment. I saw a question come across about archival rights and locks, and what's the relationship between those things. I think that the locks, or lots of copies keep stuff safe, is one way that a publisher could make its content available to be backed up online by libraries. The lock software is fairly well known, fairly inexpensive, and is one way that a library could make a backup copy, a working backup copy of content that they purchased. So there is a relationship certainly between archival rights and locks being one way to secure those archival rights. That's about it for me.
Okay, thanks. So I'm going to go on and touch on manifest assent. Manifest assent is somewhat related to click-through licenses, although, I think it'll ring a bell for you. So let's sort of look at manifest assent separate from click-through license, which I think they'll come up shortly. One of the manifest assent is the idea that by using a particular resource, you have assented to the terms and conditions. So it's more typically seen in more consumer type electronic resources where there are a set of terms and conditions. You're not required to click anything to agree to them, but your use of that resource is intended to be your agreement with those terms and conditions. Not very typically seen anymore because they've been so difficult in terms of being able to really, it's very much like a click-through license in the sense that you don't have an opportunity to even read the terms and conditions, and it's just your use that manifests your assent to those terms. So it's not, they're very contested, they're not very common, but that's what the term manifest assent means. So there's some action on your part that indicates that you've agreed to the terms and conditions without you having to agree to them proactively through a click or something along those terms. I'm going to go ahead and
Tracy?
launch. Yes, go ahead.
I was going to say we received a question about derivative works, and I want to address it if I might. Someone asked that they receive a lot of requests to transfer VHS to DVD, and this is a pretty common question. We get that all the time here at Penn State also. And they asked if it is legal for libraries to do that or if that is considered a derivative work. Section 108 addresses this in the copyright law, as Bob noted. If someone also mentioned the new fair use guidelines that ARL put out that also address this in a way as well. So I'm not going to be providing any kind of legal advice, but I always suggest to people, if you want to be able to use the DVD broadly, the copy that you make, that first of all you need to really attempt to get permission. Because VHS, as much as we don't use it very often anymore, is still not considered a dead medium. And that's the criteria under which you're allowed to freely make a copy transfer a format from one to another, as if the existing format is no longer viable. But I don't know about you folks, but I still have 2 VHS players in my home. Being a former film person, that's probably why I do. But they are still accessible, and so you really do need to get permission to make that copy or try to buy one if you can, even on the used market. Thanks. Sorry about that.
No, are there other, I'm not watching the question box, so are there any other questions that we need to respond to at this point, or?
I think some of them will come up.
We do have a lot of questions that have come up. Would you like to answer them now, or would you like to go forward and then answer questions?
Yeah, I think we should keep moving just for the time being. We have a couple more slides, and I notice we're getting on to almost 2:30, so maybe we should continue to move through.
Okay.
There's a poll open now asking you about sort of the process of licensing in your library, and I can see that we've got people voting at this point. We've got about half of the attendees have selected sort of the process that's most like their own.
Okay.
I'm going to just give it a few more seconds. We're up to about 80% voting. All right, I'm going to go ahead and close the poll, and you'll be able to see the results of this. Can you see the results, Bob?
Yes, I can.
Can you read them? I can't.
Sure. I can. You know, it's very interesting actually. Library staff do. 28% said library staff review all the licenses and can sign off. That's a little higher than I thought it would be. 37% said library staff can review, but sign off is done by the higher administration. 20% said library staff review, but it also goes to a legal department for sign off. 12% said all contracts go to the legal department for review and sign off. and then 4% says their consortium handles all license review and sign-off. I would have thought that 4% number might be a little higher. So that's interesting results. Yeah.
Yeah, that is interesting. All right, thanks. The next question that we asked in the survey was, let's see, why is it not? Please tell us about the biggest licensing challenge or single issue on which you'd like some advice or coaching. And the results of that last poll lead really well into this managing time for the process of licensing, because one of the things that I think is a really good way, someone said that their biggest challenge is finding time to go through all of this stuff. So I think one of the really good ideas here is to have your consortium do it. Even if you don't have them sign off on the license agreement, have them negotiate the terms. At NELCO, we typically do sign the license agreement as the agent on behalf of our member libraries, but sometimes that's not possible. And when it's not possible, we negotiate the terms for our members, and then the members sign that agreement directly with the information provider. So I think that's a real time saver. And then the other really time-saving process is having that standard license agreement that I talked about early. Create a standard document that you work from, rather than having to reinvent the wheel every time. And if you go through this process, look at the things we talked about in the first slide. What are those things that you need to have in your library? And start with, rather than starting from scratch, when you are licensing something new, hand that vendor or that publisher, hand them your standard license agreement as the starting point, and you will have saved yourself a lot of the time.
Agreed. I would just contribute from the publisher side. If there's anybody from Springer on this webinar, they'll probably laugh, but they know that I tend to write things in kind of longish rather than short. But I think it's useful for a publisher to try to fit all their major terms on one piece of paper, on one side of one piece of paper, and come up with a single-page listing of just what your allowances are, what those things are, so that you can hand that one piece of paper to somebody to show them that these are all the things that we allow. And maybe it's a meeting of the pieces of paper between the publisher side and the library side. But the more it can be condensed, the more it can be made sense of. And so the effort that goes into putting it down onto one piece of paper, I think, is worthwhile. Let's see. How did we want to divide this up? Yeah. I think we had questions actually from the publisher side, which I think I'll try to address, about pricing popular e-content fairly. Now, this is on the very edge of licensing. This is the pricing negotiation piece. So it's not terms and conditions so much as figuring out how to price content in the electronic world. And I would say the kinds of things that have been worked over pretty carefully are the idea of tiered pricing, that is taking into consideration the size of the client and the likely usage that could be made of the content at that site. That is the research intensity, sometimes measured by Carnegie class. But publishers will also ultimately take a look at what a client library was buying in print. That is, what was their spending in the prior world of print publishing. And they're typically going to try to make sure that they, in the electronic world, don't lose money by shifting over to the electronic world. Although, I think that the sentiment is that well, the electronic should cost less. I think the electronic should definitely add a tremendous amount of value over the print and not take away any value that the print offered. So that is the equation that brings the idea of the electronic content being at least worth the same as the print content. And then the question is coming up with some kind of useful scale that takes into account the size of the institution to make things fair across the board. That's really all I want to say about fairness of pricing. I do think that it is difficult sometimes to make the crossover from the print to the electronic world. Maybe Becky wants to talk about that multiple location concept here at Penn State.
Multiple locations at Penn State is a way of life. For those of you who aren't aware, Penn State has 23 campus locations across the Commonwealth of Pennsylvania, and because our IP addresses are all randomly distributed, we have to license as a single entity. So when I start having conversations with some folks, they start to rub their hands with glee and think they're going to charge me 23 times for a product, and we do not agree to that on principle. But here are some of the strategies that I really suggest that people use when they're looking at a license. Generally, you'll see a site restriction language that will define an institution based on geographic space, contiguous buildings, 5-mile radius, some kind of geographic distinction. We always remove that from the contract if it's in there, because that doesn't define us, first of all. And it goes back to the first slide in making sure you define your institution and you know who you're licensing for. The best thing to do is to offer an alternative. You can talk about definition of an institution under one administrative structure. So Penn State has one president and one provost and one board of trustees, and so as centralized administration does accurately define us, even though we have multiple geographic locations. So I consider that a viable alternative. Another way to approach the licensing is to talk about potential user populations. We've been doing a lot of negotiations lately with individual medical publishers, and we have, of the 23 locations, we really only have 2 locations where we have researchers at the level who could possibly use those resources. I always say if the undergraduate is going to do brain surgery in their dorm room, then we're all in trouble. So we hope that it's really just the faculty and the high-level graduate students and the doctors at the medical center who will use that content. So if I am able to isolate our users, usually the geographic distribution of our structure doesn't matter to the publisher, and we're able to negotiate. You can also discuss, if you're looking at journals in particular, base it upon who already has a print sub. As Bob said, the publishers are interested in trying to make this transition without losing income, which is perfectly fair. You know, we live in a society where people are allowed to make money. So if you've got a print sub and you want to extend electronic access, you can say, well, only 2 of my locations currently have print subscriptions to this title. I want to provide access to 7 because we centralize our licensing, but really it's really only of interest to 2 locations based upon the proof that we have 2 print subscriptions in place. So these are all strategies that you can use to try and extend access to multiple locations without paying for each location specifically. I've been asked if I have a sample license that I present to publishers. I really don't. I've been doing this now for a very long time, probably about 12 years. I do like and I'm going to get the license wrong. So Bob's actually in my office, and what's the sample license? John
Cox.
The John Cox license is actually a very good license to start with. It's available on the internet if you Google it, and it's very clear about definition. It's very clear it doesn't define an institution based upon geographic location, which is appropriate. So it's a really useful place to start. And it's really a person's name, John, J-O-H-N, Cox, C-O-X. And it's publicly available, and they're more than happy to have people use it. You're welcome, Andrea. I'm sorry, I'm answering a question as I go. And I'm just going to work my way down the other terms that I'm going to talk about, because they all have to do really with negotiating and sort of what you're expected to do when you license something. One of the questions we were asked is about policing walk-in users. Actually, I'm going to expand that to policing any user. Do not ever, ever, ever agree to do that. I tell people I have 75,000 FTE at Penn State, and there is absolutely no way under heaven that I could stand behind each one of those users and really determine or control what they're going to do with a product. You will take reasonable measures to make sure that people abide by the terms and conditions of your license. You will never ensure or guarantee. Always remove those words from the contract. Always. Reasonable measures are what can possibly be expected of you. And in fact, I've had to walk away from contracts when publishers have refused to change that language. We generally get them to, you know, when you talk about it in terms of logic, you can usually make your argument, and people will go along with you. Another question we had was about single user licenses and how do you manage those. And I'm assuming that means trying to manage an ID password login. At Penn State, up until this point, we really have said we won't manage those. We really can't. There are some people who are able to script an ID password so that a user will click on it. The login is seamless and they can go to the content. That's precarious because IDs change, passwords change. Managing that is very difficult. Sometimes the publisher is not willing to let you do it. Now, some schools will put ID passwords to resources behind a firewall so that you have to log in, and then you'll be able to see the ID password, use those, and go into and basically type it in when you go to the resource. But that again is very difficult, and again you can't guarantee how a user is going to use that information once they leave your institution. So it's really a matter of risk, how you're willing to try and manage those. Up to this point, again, we have not been willing to even deal with those. They're just too involved. The one last one we had was negotiating for good interlibrary loan rights. Ask for what you need. Don't ever hesitate to ask for what you need. So if you need to be able to provide interlibrary loan digitally, if you need to be able to capture a PDF and deliver it securely, you want to make sure that you articulate that and just make sure you get that language into the contract. You just have to be willing to ask for what you need. Yeah. And now I'm going to pass it on to...
Yeah, I just want to elaborate, if I could, on the interlibrary loan aspect. I think I've been working for the last year and a half to try to understand how the Cantu guidelines that we have, which date back to the 70s, and we're all aware of that, they were dating back to the time of using photocopiers and photocopying journal articles, and we're trying to see if they apply now to 2012, and especially to electronic books. And I see some questions that have come across about electronic book interlibrary loan. You know, I would have to say that this particular issue is still a little bit up in the air. I think it's fairly clear why a publisher that might be just fine with you sending a printed copy of their book to another library to be loaned to another individual, why that would be okay, but sending the entire electronic book across the wires would feel tangibly different. In one case, for example, when you're sending the print book, you're not actually making a second copy. In the case of the electronic book, you're actually having a copy, another copy of that book sent across to be used, and it feels like there's no constraints on it. I don't want to say that it shouldn't be done. What we've tried to say as a temporary compromise at my company is, can we think about electronic book chapters as being the content item that is the equivalent of a journal article, and have book chapters be the things that are loaned under the same basic guidelines of Cantu, which is the 5 chapters, for example, of electronic book, the same electronic book during the same year in the first 5 years of its copyright published life. Could we use those same Cantu guidelines that we use for articles for electronic book chapters? I'm still waiting, and I'm interested in feedback. I think that's an ongoing question, but it's a good question. But I think we have to, as a group and a community, determine what is really fair in that regard. I think some of these other questions about choice of a venue, that is where legal recourse would be if there was some kind of dispute. I found most publishers are willing to go with what a client says. If the client is in the state of Pennsylvania, changing the venue to the state of Pennsylvania, with most publishers, is going to be allowable. So if that's a sticking point for you, then by all means, press that model. Also,
hey, Bob?
Yes, go ahead.
Could you tell people what CONJU stands for? Some people don't know.
Yeah, it's the Committee on the New Technological Uses of Copyrighted Information. So again, that's Committee on New Technological Uses of Copyrighted Information. It's not really new anymore. It dates to the 70s, but it's what we have. If you Google CONTU, C-O-N-T-U, you'll be able to read more about and find the text on that, I think. But that is kind of an area that I've been exploring with a number of groups, including my NASIG group, about that. So we're still trying to determine what really is appropriate there.
This is Tracy, I just want to say a little bit about the choice of law and venue, and that is that you need to take a careful look at the choice of law. Refers to the actual law that will apply to you. So especially if you're dealing with non-U.S. publishers, you want to be sure that you're not subjecting yourself to the law of a foreign jurisdiction. And oftentimes you can't do that. You're governed by your institution's legal counsel, and you cannot agree to being governed by the law of a foreign jurisdiction. And choice of venue is different because that's about who will have jurisdiction to hear the case. So you could be required to, let's say, adjudicate the case in Hong Kong under the laws of, New York or something like that. So choice of law and venue are both key issues, and you want to, if the publisher or the person you're licensing with will not use your, I typically try to have this choice of law and choice of venue be the state of the subscribing member. So if the particular member of the consortium is in New York, the license terms will say the law and venue of the state of New York. If the licensor won't do that, then what you can do is just remain silent on this issue in the contract. So in other words, you just take it out completely and you don't address choice of law and venue, and that way you're not subjected to those. If you ever go to court over it, then you'd have to deal with those issues, but you would remain silent in the contract. And I also,
unless, Tracy, the choice of venue is Australia, in which case you always agree to it.
Yeah.
Sorry, I couldn't read.
The other thing, someone asked about what percentage of content being removed would constitute a material breach, and in my mind it's about, I'd say, in the 30 to 35 area, maybe even 25% of the content being removed constitutes a material breach, but I would spell that out in the agreement. What you think, because for different resources it may be different amounts depending on what the particular resource is. But if you have in mind, if I lose 25% of this content, that to me is a material breach, then write that into the terms of the agreement. So that's just responding to that. And then someone else asked a question. They said a real newbie question, I think they said. And it was about a license agreement emanates from the publisher and is negotiated with the library. The library does not prepare its own license agreement. Is this all correct? Well, I would say that's typical, but it's not. You could just as easily provide the licensor with your agreement. Say, here's these are the standard terms that we need to have in our agreement. So it only sort of emanates from the publisher because that's been sort of typical, but it's not mandated or necessary in any way. You could provide them with your own license agreement. So that's just answering a couple of those questions. And I do want to go back to this click-through, the fourth bullet here, risk assessment on click-through license provisions. One thing that you need to pay attention to is when an information provider, someone that you've licensed with, you've got a license agreement, and they also have a click-through on their website. So in other words, whenever you go to the the splash screen of that resource, there is a button that says, I agree to these terms. You want to make sure you don't have that because you've already licensed the content. So unless you've agreed to click through some users to be parties to the information provider. You do not, through the use of click attention to any agreement to be in the license.
I think it is okay, or is Trace? I'm doing the same thing.
Okay, I'm not.
Video is
on. I'm going to continue assuming that it is.
Seem to be back.
So
yeah, we're better now. Sorry about
okay.
that, folks.
Okay. All right, so I'm going to move on to the next. It's this continuation of the same question, actually. So the challenges. We're really getting short on time here, so we want to run through some of these. I was asked to look at. Sure.
Yeah, I just want to one thing. A couple of people have asked about the ARL, recent ARL guidelines. I think it's worth offering a word on that. These are Association of Research Libraries, ARL. It's really a commentary on both fair use and copyright, and their interpretation and of what fair use is and what it could be, and giving examples and making it a little bit more concrete for people. And I think it's always to be appreciated that groups seek to kind of update everyone in a new environment about how to interpret, guidelines that were created quite a long time ago. So, I've read through them a few times as a publisher. I think they're reasonable. I will say that my company is kind of liberal when it comes to these things, so it makes sense that I would think they were reasonable. I think other publishers should look at them, and they should be part of a good dialogue. But in general, I think they make sense. To me, they make sense. They're educational use. Also, I would say that we had. I'm going to just. I think to be fair to our Canadian friends, I want to say that I did research the Canadian fair dealing law. It's not quite the same as our fair use. So Section 29 of Bill C-11, the Copyright Modernization Act, if that passes, and I don't believe it has yet passed in Canada, it would allow for broader educational use somewhere along the lines of fair use and copyright in the United States. But it's also important to note that you would only rely on that in Canada if you were unable to secure proper bilateral rights with your various publishers and vendors that gave you all the educational uses that you needed. So if it's only really relevant if you're backing off of licensing and relying completely on that Canadian fair dealing law. Otherwise, your license with your vendor, your publisher, is going to trump that law. Anything that you do bilaterally trumps that law, as it would in the United States, trump copyright law if you agreed to things that were, for example, more liberal than might be present in copyright law. Okay, Tracy, back over to you.
Okay, we're going to just talk about acquiring and managing usage statistics. This was a question a lot of people had. And the question was sort of about just generally managing that information. And usage statistics can be provided by the vendor in a number of ways. They can be just pushed to you so that you're receiving them on a regular basis. But what I've seen more typically is you have to proactively go somewhere and and get your usage statistics. Typically, the information provider might give you an administrative password. You go onto their usage statistics site and you download those usage statistics. A couple of things that you might want to think about here as usage statistics become more and more important in these budgetary times. We want to make sure that the things we're licensing are actually being used by people. So as you look at usage statistics, you might want to think about counter compliance. Counter is counting online usage of networked electronic resources, C-O-U-N-T-E-R, and it's a set of standards for the provision of usage statistics. And you can see if you go to the Counter website, that's counter.org, you can see a listing of what publishers and information providers have been given the seal of approval from Counter that they are providing usage statistics that conform to this very clear standard. So you want to take a look at counter.org to look at the usage statistics issue. The other thing I'm going to address here is the renegotiating. The question was, do terms need to be renegotiated on every renewal? And this is really about including automatic renewal clauses in your license agreement if that's something you want to do. The one thing I would caution is if you have automatic renewals in your license agreement, you need to make sure you have you've put in place some sort of regular process to review the license agreements, because if you have automatic renewal, you might come up on 3-5 years and you haven't looked at those agreements in a long time and they don't even make sense anymore given the current technology environment or something else that has changed so dramatically that some terms don't even make sense in the agreement anymore. So make sure you have a process in place to review those if you have automatic renewals in their license agreements.
Okay, Tracy, I think Becky wants to cover licensing and fair use and which trumps which, and I want to throw in a couple of comments before we leave for the corporate and the federal libraries out there and their licensing concerns.
Okay, we did have a specific question asking if licensing trumps fair use or licensing trumps copyright, and the answer to that is yes. Fair use is part of the copyright law. It's just a subsection of the entire copyright law. So in both cases, yes. If the language in your license specifically prohibits you from behaving in a way that is permitted under copyright law in the broadest sense, then you've given that right up. So it's very important that you understand your rights under copyright law before you start looking at a license. That's some basic information you really should have before you start reviewing licenses at all. And we did have somebody ask, please get to the personal liability question, and I understand this one, believe me. I am not an attorney. One of the questions we were asked is if you have to be a lawyer to do this. No, I have a master's degree in film. So that tells you that I just do not have a law degree or a law background. However, if you are signing the licenses, if you're responsible for them, then you're doing that under the purview of your position. Your institution should cover you in terms of liability because you are acting as an agent of the organization. Unless for some reason you behave in a way that is completely out of bounds and you agree to sell a building in terms of a license or something like that, I mean, unless you do something really strange. If you're nervous about that, don't be the person to sign the license. Kick it upstairs. Have your director sign it. Have your head of collections sign it. Even send it to purchasing, to your business office, your purchasing office, if that makes you nervous. But you should not be personally liable. You are just behaving as an agent of your organization. But clarify that with your own institution to make sure that that is understood before you start, before you do something that's going to make you nervous. You don't want to have to be nervous in performing your position.
On the corporate and federal library side, I think in my experience, the kinds of issues that come up there have to do with actually Becky's multiple site situation, where a corporation may have offices globally, a multinational corporation. Federal site agencies often also have multiple sites. And the question comes up, well, how do I license for that? And it really, that becomes a financial negotiation to have access available across many sites. I think that publishers would rather, if they had the chance, go ahead and license to the entire set, but I do understand that that can be the issue. In that case, you're not talking so much about the legal terms of the license, but simply what makes sense. And typically, it's also for smaller amounts of content that maybe publishers would normally sell. That is more directed pieces of content, smaller sets of content than would normally be made available, let's say, in the academic environment. So it's two phases. It's smaller subsets of content that are specific to corporate federal situations, and also it's the multiple sites. And I think both of those things are and should be negotiable, and it's just that those elements come to the top in those kinds of negotiations. I don't think there's any specific legal things other than perhaps disclosure agreements that you may be bound to, non-disclosure agreements and things like that that you have to take special care of in especially the federal, maybe the certain state library situations. That's about it.
Okay, it is now 2 o'clock, so we are going to have to wrap up the webinar, and I'd like to thank Becky, Bob, and Tracy for serving as our licensing experts and providing us with this update and trying to answer a lot of your questions. And thank you, too, to everybody who attended, especially for submitting questions and being involved. I know there were a lot more questions that were submitted than we were able to answer, and fortunately, the presenters will get a copy of the questions, and I think we're going to do our best to get those answered and maybe even get them posted up somewhere. For those of you who attended, you're also going to receive a short online evaluation form, so please take a few minutes to respond to the questions and return the form to us. The comments that we receive are reviewed by the ALCTS committee, and we use them to plan additional continuing education offerings. I do have up on the screen the ALCTS website, which is recently redone, and you can find information about upcoming ALCTS webinars, and they're featured on the ALCTS homepage. We have a number of webinars that are scheduled for later this spring, and we're also working on our schedule for the summer and fall. We welcome suggestions for webinars and other continuing educational opportunities. So feel free to suggest topics through the link on the ALCTS website. And just before we sign off, I'm going to thank Jackie Samples, who provided technical support for today's webinar. She and her colleagues on the CE Committee's Technical Support Subcommittee make us possible to present these webinars so smoothly. Although we did have our audio problems, which certainly, that's first for me. So thank you again for joining us this afternoon, and we hope that you'll be able to participate in other ALCTS webinars in the future.